Welcome. My name is Hillary Burrill, and I head Georgetown's Institute for Technology, Law, and Policy, and it is with great pleasure that I introduce and welcome you to our first speaker series of this academic year hosted by the Institute. The Institute is a think tank here at Georgetown Law where we do original policy work and convene with collaborators, technologists, faculty, students, and experts in cross-disciplinary fields. At the Institute, we spend a lot of time thinking about how we train lawyers and policymakers to better understand the ways technology impacts our society. And today's topic is right on point. Right now, we are dealing with our pandemic and we are dealing with our issues of privacy related to that pandemic. We provide, as part of the Institute, more than these tech speaker series, we provide extensive courses to students in technology law. And we provide novel courses such as programming for lawyers, computer programming for lawyers, and novel programs like our Tech Law Scholars Program and our new Masters of Law and Technology. It is my pleasure to introduce our host of the conversation, a different Jennifer Sturiale. Not our speaker, Jennifer, but Jennifer Sturiale is our esteemed academic program director, and we are very fortunate to have Jennifer and her expertise here at the Institute. Jennifer joins the Institute from Harvard Law School, where she was a Klomenko Fellow and Lecturer of Law. She oversees the offerings in technology and law for the LLM Tech Law Scholar programs and the Master in Law and Technology, where she has worked to create a new curriculum and new course for the inaugurants this year. Ms. Sturiale is an experienced teacher and scholar. She writes about intellectual property, antitrust, civil procedure, complex litigation, and issues at the intersection of all of these disciplines. She has recently published an article in the Utah Law Review about the Federal Circuit's choice of law rule. In addition to teaching at Harvard, she was a visiting professor at George Mason's Antonin Scalia Law School, and she taught civil procedure and intellectual property. She was an associate at Cravath, Swain and Moore, and most importantly, she is a Georgetown Law School alum. Jennifer Sturiale, we are pleased to have you start, and with that, I will pass it along to you.
Thank you, Hillary. I'm Jennifer Sturiale, and today we are kicking off our tech speaker series with our first guest, Jennifer Oliva, another Jennifer, who will be discussing surveillance, privacy, and app tracking in light of COVID-19. Jen is an associate professor of law at Seton Hall University School of Law, where she teaches, among other things, health law, evidence, and contracts. She, too, is a 2004 honors graduate of the Law Center. While attending Georgetown, she was a public interest law scholar, as well as an executive editor of the Georgetown Law Journal. She received her undergraduate degree from West Point, and in fact, before attending law school, she was an officer in the Army. Professor Oliva also has an MBA from Oxford, which she attended as a Rhodes Scholar. This summer, Professor Oliva and 50 other scholars and health law and policy experts put together a report assessing the United States' response to the pandemic. Jen specifically addressed app tracking, which she'll be discussing with us today. And now I give it over to you, Jen.
Thank you so much, Jennifer Sturiale. It's no greater privilege in the world to have a former classmate and an esteemed legal scholar who's recently at Harvard Law School and running this center invite you to be the first speaker in the series. So thank you, Jennifer. This is really a true honor for me and privilege to talk to you guys today. Hopefully I can keep it entertaining. I do realize that we are on Friday afternoon, so I'll do my absolute best here to ensure that everybody sticks with the program. All right, so I'm going to be talking about surveillance, privacy, and app tracing. This project, as Professor Sturiale already mentioned, was linked to a much larger project about giving legal recommendations and policy recommendations to American policymakers in the midst of the COVID crisis. So it has a true look at COVID, but the bottom line at the end of the day, the privacy laws that I'm going to talk about here would apply across the board when private entities are actually assisting government entities at the local, state, or federal level in developing technologies that help us trace contagions. All right. So here's my agenda. I'm going to give you a little background on traditional contact tracing, which, by the way, is where we're at right now. I thought by the time I gave this talk, we'd be well into digital track and trace technology, which the United States is lagging on right now. I'll talk about the health data privacy laws that attend to this process. And I have a series of legal and policy recommendations that I'll probably leave to the Q&A, but are certainly available in my paper if you want to check them out. All right, traditional contact tracing, very interesting. Look, you see the old plague doctor here with the beak that's stuffed full of cloves and all sorts of other aromatics. When we used to believe in the miasma theory of disease, before germ theory was developed in the late 19th century. Okay, and you see this doctor with a staff that's often 6 feet long, which is very interesting because it didn't involve anything to do with the miasma theory, but it keeps us reminded about the social distancing 6 feet here involved in COVID. Traditional contact tracing dates back to this time and really 2 large plague outbreaks, the bubonic plague outbreak, and right before that, a huge syphilis outbreak in medieval Europe, okay? And it's a 3-part test, okay? It's a 3-step process. First, what you have to do is find a way to identify infected individuals. How we do that in modern times, of course, is by testing individuals with therapeutic diagnostics. Number 2, interview infected individuals to identify who they've been in contact with. Our standard right now, under CDC rules, is you've been within 6 feet of somebody else for more than 15 minutes. Okay. Number 3, test and isolate the infected individuals and their contacts. This is an incredibly invasive, time-tested process. Okay. And I'm going to talk to you about the strengths and weaknesses of traditional contact tracing and why we believed back in late March, early April 2020 that digital contact tracing would save us from the flaws that exist and are hard to get around in traditional contact tracing. All right, traditional contact tracing's benefits, it really helps us detect and mitigate the spread of contagion. It's incredibly important in a contagious disease context like COVID-19 or syphilis or bubonic plague to understand who folks have been in contact with. It also encourages, through the contact tracing, the expert public health person contacting an individual and encourages individuals to engage in safe behaviors and safe social interventions that can be communicated to them on a one-on-one basis. Of course, people are very concerned about economic recovery and reopening. Contact tracing has always been lauded as being able to help that happen faster by nipping the disease in the bud and maintaining contagion. And most importantly, particularly in the context of this disease that seems to target particular high-risk populations, here we're trying to protect our seniors, people who are high risk for not only getting affected with the virus, but suffering debilitating results and possibly even succumbing to it. All right, huge issues here. Slow, passive, and irritable holes. This is in quotations. Seema Shah wrote a wonderful book in 2016 entitled Pandemic, very easy for all of us to remember, where she criticizes traditional contact tracing issues and looks to the future of digital tracing to make up for some of these defects. Why is it slow, passive, and irritable with holes? It relies on human memory and honesty. Now, something that I want to tell you, many of these questionnaires, when folks test positive for COVID, started out with questions like, who did you sleep with last night, and moves into more invasive questions from there. Now, as I'm sure you can imagine, if you get a phone call from a contact tracer asking you really invasive questions about your personal contacts, your religious contacts, your political contacts, and your personal contacts, insofar as who you're communicating with or sleeping with, that can be really chilling in the conversation. Even if you are willing to go forward for hours on the phone with these folks talking about this, you also have to have perfect memory. Right? So it's perfect human memory and honesty. It would be very difficult for most of us to look back on 14 days, which is what we need to do with this disease, and remember every single human being that we've had any contact with. It's especially difficult for people who are essential workers. Imagine somebody who works in a hospital, somebody who works in a grocery store, to remember every single person that stood in that line beyond the 15-minute period. So again, this issue, traditional contact tracing has its limitations. It's invasive and time-consuming, relies on public trust, and most importantly here, it relies on accurate, widespread, and timely testing. And one of the things I'm going to tell you about traditional contact tracing that is also true about digital contact tracing is, if you don't have the accurate, widespread, and timely testing, both of these systems fail on their face. Okay, and the United States has really lagged on this. The public trust numbers on talking to public health workers about this are also poor in the United States. So from the beginning, we knew that we would have a struggle. Here's an example of such a struggle. And I used a home state example. I'm standing here in Jersey City, New Jersey, and Hudson County right now, talking to you with New York City in my back. We had a big party, 15 to 19-year-old teenagers, more than 100 of them gathered in Middletown, New Jersey, and had a big party that presumably involved alcohol and all sort of other smooching and teenage kind of like behavior. Well, the contact tracers in Middletown really tried to get a jump on this because immediately the numbers shot up, and you would not have believed how difficult it was to contact trace this group. The parents were disincentivized from telling the truth because they didn't want their students to be penalized, prevented from going to Princeton, or otherwise subjected to law enforcement for underage drinking or other things. So they were reticent to talk to the contact tracers. The teenagers themselves were incredibly reticent to be either honest with their parents about having been at a big party that involved alcohol, and or talk to contact tracers because they don't even like to pick up the phone, and they were not text. This was a huge event that ended up, more than 60 people ended up being positive and transmitting this to several other people. And it's just a classic example, and I wanted to use my home state rather than picking on somebody else. This is right in my backyard of how difficult this work can be. So let's talk about digital contact tracing is supposed to save us. Here we go. Google and Apple developed these protocols that work on both of their phones, both Apple and Android phones, and that would help with contact tracing. And here are the two things it was supposed to be able to do. Beat down the stigma that's attached with telling somebody who you slept with or who you've been around, as well as the human memory failings that work on this. It's cheaper, it's faster, it's going to be more accurate, and digital contact tracing is going to come and save us. Here's the problem, and I already said this already. Number one, we don't have accurate, widespread and timely testing in the United States to this date. Okay, we've improved on that, but it's always been a failing of the system in the United States. And if you don't have that, you can't nip a disease that has widespread contagion while someone's asymptomatic in the bud. Okay, this is a huge problem with this particular disease. Digital contact tracing on iPhones using smart technology and the most recent technology often excludes high-risk individuals because they don't have access to the most recent phones, they don't use a smartphone, they don't have digital platforms, and therefore they can't participate in the process. It also raises heightened privacy and civil liberties concerns that I'm going to talk to you about today. It's one thing for you to be able to control what you tell the contact tracer about where you've been and who you've associated with. It's another thing for your phone to be showing where you're at and where you've gone and who you're talking to and who you've associated with. And you always need, because it excludes certain people and requires building trust, augmentation with traditional contact tracing. All right, so there's two types of technologies. I'm going to talk about them real fast, and we're going to get into the law. Location applications are highly disfavored. This is where your phone, here's my cell phone right here, okay, uses the GPS technology and the cell site location data to ping where you are physically present on planet Earth. Okay, so I'm standing X, Y, and Z right now, longitudinally, latitudinally, and you know where I'm at on planet Earth. This is highly disfavored for several reasons. First of all, it gives us a ton of information about where people's going all the time. You're literally being GPS tracked. Okay, and this is problematic under case law, privacy law, etc., because it shows if I'm going to get plastic surgery, it shows if I'm going to my church, it shows who I'm associating with politically, it shows any number of things that could be highly problematic and stigmatizing to me. All right, but it's not accurate enough to be effective in this situation, particularly in rural places. This is because cell site location data can maybe pin me down on a New York City block and tell a lot about me, but in rural Iowa, it won't tell me anything about other humans that I've been around 6 feet within for 15 minutes. Okay, so it's accurate enough to pinpoint my location in highly congested areas, but it's not accurate enough to tell me all the people I've had contact with in highly congested areas, and most certainly not in rural places. So it's not accurate enough to reveal COVID contacts. So what we've relied on or looked to in the United States is Bluetooth signal technology. This assumes a bunch of things. You have your phone, I have my phone, and we both have it turned on, and we both have the same app downloaded. Okay, now the signal between our phones tells us how far apart we are and how long we're that distance apart. What the phone does then is say, oh, you've been within 6 feet of this other human with their phone on their person or their body for more than 15 minutes. So it logs the contact. Nothing else happens after that unless one of us tests positive, logs that into the system. Then all of our contacts for the past 14 days are contacted with a unique identifier and said, hey, you need to isolate immediately and you need to go get a test. This is preferred on privacy and effectiveness grounds because, of course, it doesn't reveal your physical location on planet Earth. Okay, it also can use unique identifiers that doesn't even identify you as the contact. So many privacy experts prefer proximity applications because they're more effective at close range, right? And they protect your privacy and your associations way better than GPS and CSLI data. There's a lot of variations on what happens next. Okay, here's the big issue. I already talked to you about public trust and widespread adoption. People have looked at this and said, look, at least 80% of smartphone users have to actually be using the app for it to be effective. Okay, and that's about 56 to 60% of the overall US public. There's widespread mistrust in this technology, and it also has over-inclusivity and under-inclusivity problems. The first thing I want to tell you about that no one talks about is that when you have this activated on your phone, the app, it drains your phone battery really badly. So people are incentivized to turn it off even if they trust the system so they can use their phone for its normal functions. So it's incredibly draining and taxing on the phone. And very few people ever talk about that. So you're incentivized to turn it off so you can actually use the phone. Second, it's over-inclusive because Bluetooth technology counts everything. So if I'm in full PPE during surgery and I have my phone on me, it's going to count that. More importantly, it's going to count me, and there's a huge concrete wall. I have no chance of exposure in a particular environment, but I'm still 6 feet away from a coworker or somebody in the next building over beyond that wall. It's still going to log that contact. It's going to log contacts on highways. I'm driving down the road and I'm within 6 feet. I'm in the passenger seat. That person's in the driver's seat. But there's very low risk of any kind of transmission of the disease there. So it's over-inclusive. More important, it's under-inclusive. Okay, so you have to have your phone on your person. You can't set it down or set it over in the kitchen while you're talking to your friends sitting on the couch. Okay, you have to have the data plan. You have to have the technology, right, to actually make this work. All right, so it's way under-inclusive insofar as Jennifer Storielli and I could be having a conversation on her couch, sitting very proximate to each other for an hour today, and neither one of us would get logged if I pushed my phone to this side far enough apart from us, and she takes her phone and pushes it to the other side of her far enough apart that we're more than 6 feet apart. So the surveillance is incredibly under-inclusive here, even if you have the tech, and of course, many people don't have the tech, and of course, many people don't trust the tech. So we have a lot of problems. The prevalence of digital contact tracing apps in the United States is very low. MIT has a COVID digital contact application data tracker. You can check it out for yourself. It's very interesting. Only 4 states have indicated that they're going to use this. And this is absolutely right now the United States. The fair thing to say is that we're relying on traditional contact tracing. Experts have estimated that we need about 100,000 contact tracers in the United States under the traditional system to make it effective. Right now, NPR did a big survey in July. We have about 37,000 contact tracers in the United States. So the system is largely fragmented and understaffed. So we're not doing a lot of effective contact tracing right now. Even if we were, we have big problems. Let's talk about this. So, as I'm sure many of you already know, and I don't need to give you a lecture on public health law, the states have the primary authority under contact tracing, okay? They're primarily responsible for it. The federal government's role, okay, is under the commerce and taxing powers to provide resources to states to make this happen. So the federal government could fund a public health workforce to do this or fund the technology for people who can't afford it. But the primary responsibility here in the 10th Amendment, police powers, is the states. That's our structure. These powers are not unlimited. I would argue to you that this would be upheld under virtually all the laws that exist in the United States, and I'll show them to you right now. But it has to be reasonable and proportional. It has to avoid harms to people. So one of the things I always tell people is make sure your questionnaires do not ask questions, privacy-related questions to people that go outside the scope of what you would need to do in order to contact trace COVID. We don't need to ask people about sexual behavior and other things that go beyond the scope that might create stigma or cause unfairness to them. It's also incredibly important whether this information is shared with police, EMS, or other entities that could actually create harms for people under number 4, harm avoidance. Obviously, under number 5, you can't do this in a discriminatory or arbitrary fashion. So you couldn't target like Asians or certain groups of people at the expense of others. It would have to be a universal, fairly attributed law across the board for a state to enact a statute that requires everyone to comply with contact tracing. There are some privacy law implications here. We have an implicit right to privacy. This was decided in 1977 in a case called Whalen versus Roe that involved prescription drug monitoring. More recently, we have a Fourth Amendment reasonable expectation in health data privacy, and the case Ferguson versus City of Charleston tells us that. This is a case that involves a public hospital collecting, surreptitiously collecting urine samples on pregnant women to determine whether or not they were drug users, and then sharing that data with Child Protective Services and the police without consent of the individuals from whom they were collecting data. The Supreme Court said that's against the law. But there are huge exceptions to any of these rules, including what the United States can do at the border and what happens once you transfer your information to a third party. And I'd be happy to talk about Carpenter in the Q&A. All right, most people think that HIPAA is the law that's going to save us. HIPAA is one of the most misunderstood laws in the history of the United States. There's all kinds of Twitter accounts dedicated to HIPAA bad takes. And that is because, look, it's HIPAA, not HIPAA. HIPAA doesn't apply. Look, HIPAA's going to save you. Here's another example. I'm protected by HIPAA. Look at this. HIPAA is your refuge. HIPAA doesn't help you at all here. And here's why. HIPAA only applies to routine entities that engage in the healthcare delivery system. And by that, I mean your healthcare providers, your insurance plan, and folks that work with them as business associates or clearinghouses. Those are folks that help them with their data in the payment and delivery of healthcare services. So that does not include your state public health agency as a general rule, because they are not delivering healthcare. All right? So HIPAA is generally not going to help you here. Moreover, as long as your data is de-identified, meaning your name and identifiers like your address and social security number are removed, even an entity that's covered by HIPAA will be able to collect this information from you under current US law. Let's assume that none of that stuff's even in play and HIPAA is as broad as people think it is. Well, there's 12 public policy exceptions to the statute, including, look, health oversight activities and threats to health or safety. So again, even a covered HIPAA entity would be able to get out of this, and you would never be able to bring a private right of action. HIPAA does not give individuals the right to vindicate their rights under HIPAA, even if they are violated or offended by a state entity. The Department of Health and Human Services on the federal level at the Office of Civil Rights has to vindicate those claims, all right? And so we've got all of these emergency exceptions, very few people are covered, all of these defenses, and you could never bring a private right of action. HIPAA is incredibly unhelpful in this context. Some state data protection laws are a bit better. California has the best one, the California Consumer Privacy Act, which went into effect on January 1, 2020. It allows you the right to correct your data, delete your data if you see a problem. You can bring that private right of action, but it doesn't apply to HIPAA-covered entities, all right? And it also exempts information that is held by providers under this Confidentiality Act. So this California Act would give you much more protection against a third-party entity not covered by HIPAA, but would not do more than HIPAA under those public health emergency exceptions for entities that are covered by HIPAA. All right. I just want to let you know, and then we'll open it up to Q&A, that there have been 3 statutes that have been introduced in the United States to try to deal with the fact that our healthcare data laws do not cover the situation of digital contact tracing and do not protect consumers. The most recent of these acts is called the Exposure Notification Privacy Act. It was introduced in the United States Senate in June of 2020. Okay, and it adopts a lot of the things we just talked about, the CCPA, right? You've got to voluntarily opt into the application. You need informed consent. The entity that is collecting the data should not collect more than what's minimally necessary to actually contain the contagious disease. They cannot sell your data for commercial purposes. The data has to be deleted once a contagion has passed. And it allows you to request to opt out or delete your data. You still don't have a private right of action, however. This is moving in the right direction. My recommendations here are more dramatic than this and do include a private right of action and funding that allows everyone to opt into the system so they want. I will conclude. I think I'm at the end of my time, Jennifer, and go ahead and take the Q&A. And I will say that in my paper, I do have the legal and policy recommendations that I make, and I'm happy to answer for those. So I will stop, Neil, and thank you for your time.
Thank you. So we're going to switch to the Q&A. I'm going to start with a couple of questions, and then I'm going to take some questions from our attendees. So, Jen, one of the things that occurred to me is that, broadly speaking, you touched on many things, but you touched on 2 things in particular that I think are worth noting. One is the effectiveness of app tracking technology, and both that it's over-inclusive and under-inclusive. And then the second thing is the privacy implications of the app tracking technology. So those things considered together, I wonder whether the costs to privacy are worth it if the technology isn't that effective. And I wonder if you have some thoughts about that.
I do have thoughts about that, and I think it's particularly problematic. And one of the reasons why I'm interested in this area of the law is that we often think that like we can do these things and folks assume that they'll be protected under HIPAA even when the technology is hugely flawed. And one of the arguments that I do make in this chapter and will continue to make is that the technology has a bunch of flaws that can implicate people for things that they never did, and then we don't have any legal protections in the background. One of the things that I was hoping, Jennifer, that would come out of this was one of these statutes getting enacted that finally recognized all the holes and gaps that we have that don't protect our healthcare data once it's outside of the traditional healthcare context. People are wearing and I'm guilty. I'm sitting here lecturing, but I'm guilty. People have these wearables. They have these different apps on their phone. They are giving waivers and consent to third-party entities having this data, and they don't have any legal protection in the United States against that as a general rule. California law does give them some, but under the vast majority of jurisdictions in federal law, you have very few protections. So I was very concerned about the combination of how flawed the system was, who would be targeted, how easy it is to transfer this legally to law enforcement, and then what would happen going forward. Let me give you one example. In Indianapolis, right away, the public health authorities started letting the Indianapolis police know, this is back in March, know who was affected by COVID. And one of the things the Indianapolis police decided to do was to enact very dramatic procedures with people like this and stop giving people who had overdoses, who were potentially infected with COVID, naloxone, or giving them resuscitation or engaging and helping them with their health. So you can see how quickly when you start combining all this information and sharing people's health data, they might get dramatically different treatment in a healthcare emergency from EMS or the police if the police have that data. So it can really have serious implications for health and safety.
So one question that arises, this provokes for me is that let's say that we get very good at the technology so that it's not so under or over or under inclusive. Then I think, so right now it sounds like, the cost benefit analysis might be that it's not really worth it right now. It's not that effective. And we have a lot of concerns about privacy. It has a lot of privacy implications. But if the technology gets better, that cost benefit analysis might change. And so a question is then, do we then still think it's justified, or do we need to nonetheless do something else?
I couldn't agree with you more, and you could even make an argument right now that every contact trace is a potential life save, right? So even if we don't have widespread use and even a smaller percentage of the population are using these tools, and these tools are better and more predictive than the very time-intensive and expensive interviews that are conducted by the public health resources that we have under traditional contact tracing, that it's worth it. My problem is that we need to fix the privacy laws on the back end. And the privacy laws on the back end allow easy sharing of this data with no repercussion, no private right of action, no vindication, and that's been the structure in the United States for a long time. I mean, the privacy statute was enacted in 1996, and we didn't even get the privacy rule until the early 2000s. And technology has changed dramatically, and health data privacy law has not kept up. And you guys are technology experts, and you could probably take that statement and transfer it across a whole. But I focus on health data privacy, and it just has not kept up. So the real flaw here, the precursor flaw to all of this, we don't have enough testing, the technology is not good enough, is that we don't have health data privacy laws that imagines a situation like this and protects people, and then it doubles down, not as an obstacle, but instead of a tool that itself enhances public trust.
So one other thing that occurred to me in reading the chapter was that there are at least two variables that you've discussed, right? There's private versus publicly sponsored technology, and there's location tracking technology that uses GPS and CSLI data versus proximity tracking technology. I wonder if you could talk a little bit about what some of the problems with a privately created app tracking technology are versus those with a government-sponsored app tracking technology.
Okay, so given the limitations that we have under constitutional law, if you don't have a government entity, right, taking your data or tracking it, you don't have a constitutional law argument because you need a state actor. So now we're outside of even attempting to be able to make 14th Amendment or Fourth Amendment arguments. All right, so that's the real problem. And then HIPAA does not make up for that because it does not cover private entities that do not provide traditional healthcare resources, treatment, payment, etc. So that's a huge flaw in the law. Second is, let's talk about proximity tracing apps and why I'm more favorable to them because they're more effective, but I'm also more favorable to them because they're more privacy protecting. CSLI data is incredibly invasive. And like I said, if I went to the abortion clinic, that could potentially be revealed, especially where I live in New Jersey because of the congestion. If I went to a particular kind of religious sect that's disfavored, if I had a political association that might be used against me, that kind of data can track that. Proximity apps don't do that. That just tells us, Jen, if you and I were having that conversation on the couch and we had our phones with us. The Supreme Court has been particularly sensitive about this. Some people call this sensitivity about information on cell phones because there's been a sequence of cases and GPS data. And there's a case decided in 2018 that I alluded to earlier, and I thank you for the question, called Carpenter versus United States. Timothy Carpenter was alleged to have been involved in a string of robberies across the Midwest involving, ironically, cell phone stores like Radio Shack and things like this. The FBI subpoenaed his information, his cell site location information from his wireless data carriers. Imagine like Sprint or AT&T or Verizon or whoever you have as your wireless carrier. They delivered the information to the FBI and they were able to pin him down as being proximate to multiple of these robberies, which they pursued as not a coincidence and indicted him as a co-conspirator in those crimes. The Supreme Court of the United States said that the FBI is not allowed to track your cell site location data, notwithstanding the fact that it is in the hands of a third party, okay, more than 7 days without implicating the United States Constitution under the Fourth Amendment. So the argument there is you have a very reasonable right to privacy of your location data, where you are standing or located on planet Earth under really recent Supreme Court case law. So that claim, if we were using data apps that involve cell site location data, I would make an argument that it would be much harder for law enforcement to get that. That is not the case on proximity data. And proximity data may not be saying where you're out on planet Earth, but it will say who you're associating with as another human. And if the law enforcement's able to get underneath that, which they can, your unique identifier, subpoena that information, they could find out that you were talking to an associate that may be implicated in some kind of crime or other illicit activity. And that could, of course, result in you facing criminal charges.
So thank you for the discussion about Carpenter versus United States, because I had a question, and then I'm going to open it up to our attendees. So in your view, under the circumstances that is of a pandemic, is it reasonable to conclude that Carpenter versus United States would then extend to any data collected via these sorts of app tracking technologies? I mean, you talked about it, though it seems like a foregone conclusion, but do we think that I'm curious what you might think about that, because it's not obvious to me, especially given the vote in Carpenter.
I think you're right. Obviously, you're very right. I would note that the vote's stronger than some people think. If you actually read Gorsuch's dissent, I call it a concurrence. He basically says, you waived a property right here, but these statutes give you some property right and protection. But that being said, here's the problem. This is a public health use of the data. In the law enforcement context, I think Carpenter gives us some pretty good guidance. May or may not apply, but you can make a strong argument. The problem here is in the public health context, there are all these other doctrines of the Fourth Amendment that might give the state a break. And one of those is a special needs doctrine, right? We have a contagion, we have a public health emergency, you have these administrative search things. This is how the schools search the kids' lockers, right? This is how employers give their employees drug tests and make them comply with these sorts of things. So in the private context where an employer is using this kind of app and saying they're doing it for public health reasons to protect their workforce, the case law is not good. The case law is not good that you can make an argument against your employer, right, for using this or forcing you to use this, given what we've seen in this context. I will caveat all of that by saying the court does seem particularly concerned with GPS and cell site location data, and they may continue to extend this doctrine. Not a lot of people thought Timothy Carpenter would win. because we're looking at Jones and Riley and these concurrences and these Fourth Amendment cases. And it really, really undermined this third-party doctrine. But this is all criminal law enforcement context. Once you get outside of that, the court's going to be more generous and start applying all these other doctrines, and you may very well not have a claim against an employer or a state public health entity. So I cannot agree with you more that all of the things I can say that are helpful about Carpenter need to be dramatically caveated, and in the criminal law context period, but certainly once we get out of that, because we have a bunch more Fourth Amendment exceptions that could save the entity that's using this without probable cause and a warrant.
Okay, so I'm going to have one follow-up first. So in your view, how serious is the concern that the imposition of app tracking technology may then affect the Fourth Amendment calculus? That is, that the technology will ultimately affect the analysis of whether individuals have a constitutionally protected reasonable expectation of privacy in such data. Do you think that, is the concern that if individuals start using this technology, that it will erode that expectation of privacy and the constitutionally protected right?
Look, that would be, I don't even know if I want to see that case in the administrative search doctrine right now. You're absolutely right. You're pinning me down pretty good. That might not be helpful. I don't want I don't want this case to go up in a public health emergency context on the administrative search side. But I will say this, I do think it is special, especially in Fourth Amendment law, and I really think it's hard. First of all, you had Sotomayor and these folks making these concurrence statements about the third-party doctrine, and that's really been codified now in Carpenter. They really are concerned about you being traced every second of the day for hours and hours and hours. Carpenter was traced for 157 days, and the court just thought that was outrageous. And that harkens back to GPS tracking and all sorts of things. So I do think that there are strong arguments to be made here if the criminal law wants to take this data and use it against you. I wish we had a law that protected that and we didn't have to get involved in it. But right now, law enforcement has easy access to that. I will concede, and there's no good use in ever fighting with you because you're usually right, that it may not be to privacy advocates' advantage to go to the Supreme Court under the administrative search and special needs doctrine during a public health emergency to try to make an argument about privacy here now, given the exceptional public interest and the public health emergency in the context of a contagious disease. That's perhaps not the best, most strategic, wise choice right now.
Okay, so I have a question from a attendee, James Carey. He asks, is the location proximity data for these apps shared both with the tracing company and locally on devices? If proximity data is, how about we take them one at a time? I'll let you answer and then I'll pose the second question.
Okay, so the first question is, how is the data shared?
Is the location proximity data for these apps shared both with the tracing company and locally on devices?
It depends. So that's very interesting. So if you take like the Singapore trace and track system that they use there, they hired a third-party intermediary, but the public health entity, the health entity for the country, ends up getting all the data into a centralized database. So that public health authority ends up having all that information. And that's the way that was structured. So all of your address, they can contact you directly, your name, where you were at. They are getting, Singapore government health authority is getting all that data. The way that Google and apps structure their proximity apps, nobody gets your data. What happens is there's a public database, and the database only uploads the way the APIs were created by Apple and Google. And they really cared about consumer privacy here, and they really heralded themselves on it. You would get a unique identifier to your phone, uploaded, and those unique identifiers will be what talk to one another, but there would never be an upload under Google and Apple's system to anybody aside from the unique identifiers and this like non-identifying information that could be used. There's a middle of the road system, and this is the last thing I'll say, move on, that kind of combines a little bit of Singapore and a little bit of Google apps, where the public health entity gets some information in case they need to follow up or something like that. So they might get your unique identifier and like a contact number or something else like that. So there's a middle of the road approach that you can use, combining the two extreme approaches where the public health entity has a ton of your data connected to your phone, and one where it has virtually nothing besides that unique identifier. That's Google and Apple. There are middle of the ground approaches where the health authority has more information than it would under Google and Apple, but less information than it does under Singapore. And those can there can be a variety there of, you can name it, they ask what they want to from a third party entity, the public health authority does, and that's what they're collecting. So there's a wide scope of spectrum there, and that's an excellent, fabulous question, because it really runs the gamut.
So I want to have a follow-up to James's question before I ask a second one. So if we take the Google and Apple example, let's say that they identify an instance in which someone has had contact with someone who had COVID, right?
Yep.
Do the devices just speak to each other, or is there a relay of information to a health authority or the like? So is it stay privatized essentially, or is there some engagement with a local health authority or governmental entity?
No engagement with a government entity on its face the way they design it. Well, what happened is you and I sat on the couch in my earlier example. We're on Google, one of the Google or Apple pure APIs without intervention by a state agency that says, I want to change this or make this more information centric for me. I would then say, you got COVID, you tested positive. You would have to upload that information in the app. You would have to say under the app, I tested positive. That would ping to the central database with your unique identifier. And then my phone would say, someone you've been in contact with for more than 15 minutes has tested positive. You need to isolate and get a test. That's what the phone would do for me. So I would never know for sure that it was you. I mean, I guess I would know if I've never didn't see any other human being for 14 days and you and I were the only ones who came in contact with one another. But I would be notified not by your information, but just get a ping to me. It's time for you to do something. And then it'd be up to me. I would then, of course, be required to upload, I've also tested positive in order to keep the system going. So this is very user-centric. It really depends on users doing the right thing, keeping their phones on them all the time, and being honest and with the reporting to the application. But there's no additional information under the pure Google and Apple API that goes to state public health authorities, and that was incredibly intentional.
Thank you. Okay, we now have a question from Bailey Martin. He asks, you mentioned gaps in privacy protections at large, which is apparent in contact tracing adoption. Of the 4 states that have adopted MIT's iteration of Apple and Google's API, are there any commonalities among the jurisdictions?
Not that I can see right now. To be completely honest with you, I should have rephrased that. Let me be completely clear. These are 4 state and public health authorities. They sent out the survey to all U.S. jurisdictions that said, we're working on it. Right now. So whether or not that's even implemented, I'd have to go back and check. But that's only 4 public health authorities even said they were working on using the Google and Apple API when the survey was taken in the late summer, pretty recently here, now about 8 weeks now. So I don't know. I think that'll be very interesting. I can say one thing that I think that might be more satisfying to the question answer here. A lot of people have said, look, you know who's going to be successful at this? Countries that are very authoritarian, where people just fall in line, they're forced to use the app, like in some countries in East Asia, like China, etc. And that's who's going to be successful. And countries like the United States, where there's not a lot of public trust in using this kind of technology, and we have these gaps in the law, are not going to be successful. As it turns out, and people are starting to look at this, the real common thread of states that have, or nations that have been successful in using this are 2 things. A spirit of communitarianism, where people really truly believe, and it's part of the public culture, that we're in this together in a contagious disease situation, less so than people who believe my individual freedom trumps anything that matters around a community or public health perspective. And those countries have something else in common. Not only do they have that culture, but that culture has been developed recently from recent public health disasters. So for example, the countries that we see where there's high levels of cooperation have recently themselves suffered way more than the United States from recent coronaviruses, SARS, MERS, and the like. And they blame their own government for not being forceful enough or nipping it in the bud enough from the get-go. So those folks in Singapore and Taiwan and Hong Kong were very, very willing to give the government a lot of authority to nip this in the bud, because they've very recently been through public health contagions that were widespread in their nations. So I would again say to you, when we get to I say all that to say, when we get to a state by state look at this, you might see states, if we believe this is true, and it appears to be true internationally right now, anecdotally, maybe it's a state like New York and New Jersey that had really bad losses up front and did very poorly. People would be much more willing to participate in a process like this and weigh the cost benefits in a communitarian way than in jurisdictions that had suffered far fewer per capita deaths or contagious infections than these northeastern states that sort of suffered on the front.
Well, with the caveat, because we don't know yet, right? Like Texas and Florida, which had their sort of peaking later, and their politics are very different. So we may not see, even in those states where they might eventually have this sort of same suffer the same sort of losses as New York and New Jersey, but we may not see that sort of technological or the change in both the trust as well as the a willingness to use the technology.
No, I think that's right. And I think that here's another, you and I could go back and forth a bunch here because your point is so well taken. Another problem right now is that even when people are up in the numbers, it's not necessarily public trust getting developed because you see this huge increase in younger people right now because going back to school, going back to college, et cetera. And these are folks that we know are far less likely to suffer any symptoms, let alone debilitating conditions, as far as we know right now. Now, listen, if we get 3 or 4 more months into this and these more myocardial events seem to be on the uptick even for young people and things like that, that could also change the dynamic. When you're dealing with a novel coronavirus across political lines, as you well point out, Jennifer, this is very, very, very difficult to capture in the United States. I'm personally sad that we don't have systems in place right now that would even make this effective or would develop the public trust in this context. And of course, we wrote all this stuff anticipating that widespread testing would be in place and that we would have developed a little bit more communitarianism around this. And so we have a lot of front end problems, even in New York and New Jersey, that could really serve as obstacles to this being effective.
Yes, we do. So
right.
Now from Connor Kane, who asks, if we were to institute a digital contact tracing program to deal with COVID, would there be a way for us to exit from the program if and when the pandemic ends? How could we protect privacy moving forward in terms of determining what kinds of scenarios would make the use of digital contact tracing program permissible?
That's a great question. And let me just say to Connor or anybody else who had this idea, the statutes that I mentioned all deal with this data has to be terminated at the minimum, and these are the recommendations, at the end of the time when they can be useful, and that's when the contagion has been managed in a way that public health authority believe it's no longer useful. But several people have proposed that your data gets deleted, every 14 days going back when it's no longer useful or the contact tracer wouldn't be using it anyway, and then that would give you a much heightened protection because it wouldn't even sit around there for another 6-8 months, right? You would constantly be having data deleted, and that would be much more protective of individuals. But at the minimum, and I will say this, and this is fair, and I think the folks who have introduced these bills have been receptive to this, they have said the data has to be deleted at the end and cannot be contained and then sold off to other people or used for law enforcement purposes or other means or mechanisms. So it's a very good question. It is something that is weighing on policymakers' minds. And like I said, they've at least gone to, when the United States declares there's no longer a public health emergency, which has not occurred yet, presumably the data would be deleted.
So it's sort of a nuclear option of sorts, which doesn't rely on the user to delete the app, which, as many of us, I'm sure, have. Except for me, but many people have apps on their phone that they no longer use, unless I'm saying you're like me, where I diligently delete them as soon as I find them no longer beneficial. But that's not the case, right? Lots of people have these apps, and if you have this contact tracing app on your phone and you don't realize it's working in the background, right? These proposals take that decision making out of the individual's hands, and that way we could say it goes far in terms of shaping individuals' reasonable expectations of privacy because they are no longer willingly, whether passively or not, giving away their location data, right? So this is sort of takes that decision out of the user's hands.
Yeah, I think that's right. I think that's right. And it's very interesting because, Timothy Carpenter could have shut off his phone. He could have put it on airplane mode, right? But the court is not sympathetic to the government's argument in that case about that. It's sort of saying like, no, that's not good enough. So I think that we're moving in this direction. And Europe, under the GDPR, their General Data Protection Act, has already moved in this direction. You can invoke your deletion rights, but entities are not allowed to keep that data beyond usefulness, right? Material usefulness. And in this case, we can define that in some really meaningful way, right? If they're not tracing or tracking anymore, the public health entity isn't doing that, it's gone. But like I said, the best practice that I put in here was they won't use it after 14 days anyway, and they won't trace those contacts. So go ahead and get rid of anything beyond the 14. Once you're in that time period that's not useful to them anyway. It's really easy to define because they've already told us what it is.
So just to give you some perspective, we have about 5 more questions in the queue right now.
Sure.
So I want to make sure we get to as many of them as we can. And I had some that were also sent to me beforehand.
Sure.
So Caroline Craxton asks, are the apps meant to just notify users of exposure, or are there any proposals to use the apps to prohibit access to work, school, or public space without consent?
All right. And I think that question asker, who's probably a genius, already knows the answer to this question, but it can be used for both. It can be used both ways. It's technically from the public health entity's perspective, what they want you to do is be on notice and isolate and then get a test. Massachusetts went even further on this, and instead of asking, where were you at yesterday and who are you sleeping with and these things, their first questions for their public health entities, and they've been quite successful. Massachusetts, I would hold up as like the best example of how this has been done. Said, hi, we're contacting you. You might have come in contact with somebody who was contagious with COVID. How can we help you do the right thing? So the questions all go to, if you had to isolate, what could we do to make that happen? They hired all these social workers and all these other folks that say, we'll get the groceries for you. What else do we need to allow you to stay in your apartment? What other things would you need? Can we contact social services? So they present themselves as helpers that have other assets and resources on the front end and are very helpful to people. That's the best case scenario. But the person who asked the question is thinking probably not about that best case scenario that's been successful, but the worst case scenario. And the worst case scenario is real, and that is, and I think employers and probably, it's always dangerous to say this when you're on these things, but your universities and stuff are using this data obviously to affect behavior. Right, so they're using these apps to affect your behavior, whether you're allowed to come into work, for how long you're allowed to come into work. Once you come into work, we didn't talk about this today, there's a whole bunch of more technology that employers are putting in place. They're scanning to see who's near each other. They're using heat maps. All you folks in the technology stuff we can go into a large employer, an Amazon warehouse right now, and get worked up about privacy like nobody's business, okay? Because they're not just using the apps, they're using all sorts of other technology to sort of pin this stuff down. And that does affect your privacy, but it also is being used to affect your behavior, right? They're like, if you report something or tell us something, or the app gets you on something that you don't want known, that's gonna have an impact on your life. Right? They can force you not to come into work. They can not allow you to come in the building, right? So I would think about the app in that context as the same thing as something that is entirely ineffective, but everybody's doing, which is the fake testing your temperature when you go into a building, because it's not helpful at all or predictive of anything. But they're doing that as a screening mechanism to signal that they care. These apps actually they'll be using in the same way. And by the way, the first entity to use the apps this way were large hospital systems and healthcare employers, and particularly in the nursing home context, to make sure that folks weren't bringing the contagion in from home to a very vulnerable population who had been more adversely affected than anybody else in the United States from the disease. So they immediately started using the nursing homes, and the large hospital systems were the first to implement this kind of track and tracing stuff that does actually impact where you're allowed to go and whether you're allowed to come into work or not.
And I imagine that those sorts of ancillary effects, right, that come after you are found to potentially have COVID or been in contact, are the concerns that may then prevent people from wanting to adopt the technology and use it in the first place.
Well, just imagine that, you really can't afford to lose your job.
Right.
And the moratorium on the rent stuff's done. And we don't have another COVID protective bill here that's going to help you if you get on unemployment and you're in a state that's not, I'm in a state that's very generous on unemployment, but I came from a state, West Virginia, that is one of the lowest paying unemployment, right? So you're in really big trouble. So you're putting someone in a position where they have to make really tough choices around public health or their own family. And their own ability to stay in their home and their own ability to take care of their children. And in that context, I will tell you, folks are going to definitely find a way around the technology. It's not that hard, and they're super incentivized to do it.
So we have a question also from Evan Cernia, who asks, what is the point of state systems when many of us, especially in the Northeast, live in metro areas that span states? Is there any talk of regional systems developing, like what happened when New York, New Jersey, and Connecticut coordinated their COVID response initially?
I think the regional question is a really good one. To the best of my knowledge, there is nothing regionally going on around digital contact tracing. There have been other regional coalitions, as you know, that have been done. But I'll give you a New Jersey example. So my law school is in Essex County. I live in Hudson County. The main campus is in a different county. We have multiple county health authorities that easily could have influence over one individual, or they could live in one county, work in another county, go to school in another county. And the state of New Jersey needs to coordinate that, and it's very tricky. So I think that what this points out is the flaws in the system, and this is something that potentially digital contact tracing could help make up for if it was robustly utilized and put in place. It's not perfect, but it could certainly help with those kinds of things. And it could be like every third one comes to Essex County, or we do it by your home address, or we do it by your work address, or we do it by the place of contact. They could use criteria and actually figure out who has responsibility. Right now, this is such a good question and such a thoughtful question, because there's a lot of time being spent, especially, and I can tell you this because is what I'm spending my time on right now, in the university context of the student goes to school here, they live here, and they work here. And those are different entities that have responsibility. How does that get coordinated and who's responsible? And we have not done a good job in the United States at the local level of dealing with that. That is something where the state and federal resources could be incredibly helpful. Regional associations could really be good about this. People are across. Look, everybody who lives here in Hudson County besides me, I go the other way. I go to Newark, New Jersey to work. They're going to New York City to work. So they're crossing the border every single day to go to work. That's a common thing here. So a cross-border coordination between the counties that touch in New York, New Jersey, and Connecticut would be incredibly helpful. That's not in place right now from a digital contact tracing system. And New York is struggling right now with having an inadequate traditional contact tracing network. There's a great article in the New York Times, I think it was July 31st, 2020, where they give you a really long-winded tale of woe about what happened in New York City with contact tracing and how unfortunately poorly that's gone for the city. And I recommend it to you if you're having thoughts about this, so that you can kind of see how important it is to be thoughtful from a public health perspective about this and coordinating across borders. It's a great article. It was low down in the New York Times on the 31st because I think we had a bunch of other drama. I can know it's surprised. We had a bunch of other things going on in the United States at the same time that day. So it was lower down in the headlines than you might expect it to be. But it's a really fabulous article. And Jennifer, I'd be happy to send it to you to share with your students.
That would be excellent. I mean, we also obviously have the same sort of concerns that you do up in the New York metro area, right? Because in Washington, D.C.,
yes.
Virginia, Maryland, DC are so close, and our borders are so porous, obviously, that we have the same sort of issues arise. So I think we have time for one last question, and then some of these other questions, I know some of us will be convening afterwards, and we can take up the discussion. So Dan Kinney asks, what are the data privacy protections for data collected through the traditional contact tracing process?
Right.
So if we want to talk about how technology is, how technology has perhaps, maybe eroding or has the potential to erode some of our rights, I think Dan's question puts in perspective, like, well, what did we have before? What would the world have been like in comparison? Especially because we haven't really experienced something of this caliber before in our lifetimes.
Well, Dan, thank you for your very thoughtful question. These are all amazing questions. This one might really rise to the top for me because I have been arguing, and plenty of people have been arguing, that we didn't have adequate data privacy laws that preceded anything with digital technology. The difference is, so if the public health entity gets your data, presumably because they're not a HIPAA covered entity, and even if they were, which they're not, but even if they were, your university, they could still share your HIPAA data with law enforcement and a whole bunch of other entities and for research purposes and give it to other people, because there's those 12 public policy exceptions that are HIPAA. So we'd argue there should have been more controls over that information from the get-go under traditional contact tracing. The only point that I'm trying to make in this article, and Dan, I would agree with you completely on this, is that it was inadequate before, is that you at least had some control over what you wanted the public health entity to know, right? They didn't have your GPS data. They didn't go, well, you said you weren't, Jen, you said you weren't getting Botox last Tuesday, but here we have, there you were in Jersey City. So this is the only thing these folks do. And it really looks like maybe you got some Botox. They're going to come for me on that. They're going to be able to, I took my phone with me. I paid on Apple Pay. I'm done. It's over with for me. They got me. And they have that information on this. I could, of course, in the traditional sense say, I didn't have any contact with one person, and here's who it is. And of course, it's the person that gave me the Botox in the room alone. But that's all it is. And they're not seeing all these other things, and I'm not giving up so much data and so much information. And I also could withhold that information, obviously, which I would consider if I wasn't a good public health soldier. Of course, I would go ahead and tell it like I've told it to you, because I want everybody to be safe and sound and happy. So the issue really is this. The data privacy laws were inadequate before. Dan, you're absolutely on point. All these questions have been. You guys are amazing. It's just more concerning now because you have so little control over your data, and it's so revealing once you start using the digital apps. Thank you.
And so I think with that, we are going to, I know we had a couple more questions. We just didn't get a chance to get through all of them. I apologize, but some of you I know will be in touch soon enough. And I hope, Jen, you'll come back and visit us in person when the time permits. Thank you.
I appreciate it. And thank you so much again.
I'm sorry. Thank you to all of our attendees as well. I'm sorry.
Thank you guys for having me. And thank you, Jennifer Storielli. I'm a huge fan of your scholarship and work, and it's just a real honor and privilege to be invited to have this talk. Thanks to Hillary, and thanks to the whole team that supported this and made this a wonderful opportunity. Really appreciate it.
Thank you. See you guys soon.